checklist for employment and benefits law. This presentation will last about 30 minutes, and a recording of the webinar will be available on the Wagner Law Group website very shortly, and you can access previous webinars on the website as well. Let me introduce our speakers, David Gabor and Bill Scogland. Although new to the Wagner Law Group, Bill has practiced employee benefits law for nearly 40 years, and he has represented companies in numerous transactions over that period. He's located in the Chicago office. And of course, you all know David. He is of counsel with the Wagner Law Group in the Boston office. Welcome, David and Bill.
Thank you, Barbara. Bill, I look forward to working with you. I'm very excited that you've joined the Wagner Law Group team.
I look forward to working with you as well.
Oh, thank you. Every so often, I get calls regarding mergers and acquisitions. Sometimes the calls come before the transaction is finalized. Oftentimes, this affords me the opportunity to be proactive for the benefit of the client. Then again, I receive calls after the deal is done. This could require litigation to resolve disputes. Sadly, sometimes this could have been avoidable. Hey, Bill, what has been your experience?
Well, my experience has varied over the years. When I was first practicing, almost 40 years ago, as Barbara said, we routinely would get a call. We in the benefits shop would routinely get a call from the corporate people at about 10 o'clock in the morning of the day that the deal was going to close and say, hey, you know, maybe there's some benefit issues here. Maybe you guys ought to look at this. But fortunately, a long time ago, corporate folks started to recognize that benefit issues can be important. Seeing deals tank over benefit matters, seeing deals get materially delayed, seeing people be disappointed once the deal was closed without adequate attention to the benefit matters. And indeed, sometimes there is litigation.
Okay. I'm sorry to interrupt you. Have you worked with defined benefit pension plans in your analysis?
Yes, that is one of the prime areas that we're going to cover, and I think I should say at the outset that we're going to move very quickly today, and there are a number of the aspects we're going to talk about where we literally could go on for hours, and one of them has to do with defined benefit pension plans. But if you are on the buyer side, among the things you definitely should find out is if the company to be acquired has a defined benefit pension plan, and if so, the very first thing is to get your actuaries working on determining whether the funding numbers look right to them under the assumptions that they would make. If there is a defined benefit pension plan that is significantly underfunded, then probably the only way to deal with that in the deal would be with a purchase price adjustment. It is possible that buyer might have an overfunded pension plan, that the two could be merged and make the underfunding go away, and it could have good synergies in a deal that way. But if that's not there, really the only thing to do about it is a purchase price adjustment. One thing I will just mention is that for liabilities in a defined benefit, for benefits accrued in a defined benefit pension plan, there is controlled group liability. And controlled group is one of those areas that by itself could go on for several hours. But I have seen circumstances where deals were done without sufficient attention to controlled group analysis. And if buyer acquires at least 80% of the company with the underfunded plan, it is going to be jointly and severally liable for the costs in that plan. One deal that I worked on many years ago, and I will hasten to say I was not there before the deal was done. This is one of those ones where we were brought in afterwards, where the distressed company that the buyer took the company over for $1. Not recognizing that the company that it acquired had $14 million in underfunding in the pension plan, so it can be very dangerous.
Do you work with actuaries?
Yes, you definitely have to have the actuaries in to look at the reasonableness of the numbers.
Okay. Bill, can you talk about retiree medical?
Sure. Actually, this is really more retiree welfare than just retiree medical. I mean, medical is generally the big ticket item. I have seen life and disability benefits be issues, but usually it's medical. There is another thing you need to bring the actuaries in and get some idea of the reasonableness of the assumptions needed for the numbers to compute those retiree medical liabilities. One thing that's different about retiree medical or retiree welfare generally is that unlike pension plans, there's no legal obligation to fund retiree medical benefits. And in fact, the legal rules that there are really discourage funding. But it's one of the things that it is wise to do is see if there are trusts or insurance reserves that could be put to good use. It's surprising sometimes, and I've seen this even in very large bankruptcies, airline bankruptcies, for example, where there were very large unfunded retiree medical benefits, but there was a retiree life trust that had so much money in it that it would never possibly be used, even if all of the covered people were to die, and there was an ability to amend that and even things out of that. So that's something that just definitely needs to be due diligenced. Another thing that needs to be due diligenced is see whether the company to be acquired has adequately reserved the right in the documents to amend or terminate the retiree medical benefits. Now, unlike pension benefits, there's no statutory right to vesting, but there definitely has to be a reservation of rights in the documents for the employer to unilaterally make changes. One example I'll give you is you may have noticed in the Wall Street Journal just within the past week that the judge held that American Airlines did not adequately reserve the right to amend or terminate retiree medical benefits. By the way, I did work on the American Airlines bankruptcy, but I'm happy to tell you I did not write that language. That the court held did not adequately reserve the rights. Also, one thing that bears mentioning in this area is this is one of a couple of areas that we're going to mention where location matters. And what I mean by that, and that may sound a little surprising given that we're dealing with federal law, but in the Sixth Circuit, which is Michigan, Ohio, Kentucky, and Tennessee, the judicial decisions in the Sixth Circuit have made it more difficult there, especially in the collective bargaining context, to get rid of retiree medical benefits. So that's all I want to say on that one.
Okay. Can you talk about multi-employer pension plans?
Sure. First, I want to distinguish multi-employer pension plans. Sometimes the language gets to be kind of confusing because there are plans that you don't see very frequently that are multiple employer plans, which just means there's more than one unaffiliated company covered by the plan. To be a multi-employer pension plan, there have to be multiple unaffiliated employers and collective bargaining agreements. So these are all Taft-Hartley plans, jointly trusteed, maintained pursuant to collective bargaining. The scary thing about finding that there is a multi-employer pension plan at the company you want to acquire is the potential for withdrawal liability. And in order for there to be withdrawal liability, not surprisingly, there has to be a withdrawal from the plan. And a withdrawal is anything that causes a permanent cessation of the contribution obligation. So that can be the company goes out of business, the union is decertified, the business is sold in an asset deal, not a stock deal. But if there is a withdrawal, then the plan will send the withdrawing employer a bill. And that is for withdrawal liability. And that is computed, and there are several ways to do this, but what I'm going to describe is the most basic method, which is also called the presumptive method. but that is to multiply the present value of the unfunded vested benefits of the plan by a fraction, the numerator of which is this particular employer's contributions over a base period, over all contributing employers' contributions over a base period. And there are a couple of things to note about that formula. One is, since many of these plans are very large, the number for that unfunded vested benefit can be billions of dollars. So that even if the contributions by this particular employer are very small, and so that part of the equation is, the fractional part of the equation isn't very large, if it's multiplied by billions of dollars, it can work out to be a lot of money. Now the good news, to the extent there is any here, is that the obligation will nevertheless be limited to essentially continuing the current year's contributions for another 20 years. Now that obviously still can be a lot of money, but it does put a cap on it. Now this is another thing where if you really need to try to get a fix on the numbers, this, however, the buyer and the seller don't have control over because we've got a third party, which is the plan. Some plans are very good about responding to requests for information on withdrawal liability. In fact, some just send out estimated computations of withdrawal liability on an annual basis, but sometimes it can really be pulling teeth, and it can be very difficult to get a fix on that. Now, if there is a stock deal, then the plan is just going to come over, and really the only way buyer can protect itself from the liability is to give the seller a haircut on the purchase price. If it is a stock deal, I'm sorry, if it is an asset deal, if you don't do anything else, that will be a withdrawal. And so that may be good news. If the withdrawal liability isn't material, you probably will want to have it be a withdrawal so that buyer can start fresh. I won't go into all of the details, but there is a statutory method. It's called the 4204 sale, in which buyer and seller can go through some various steps, including retaining secondary liability and posting bond unless it's waived and that sort of thing, and avoid the liability even in an asset sale. This is the other area, by the way, in which I'm going to mention that location may matter. In the 7th Circuit, where I'm sitting this afternoon, the 7th Circuit is Illinois, Wisconsin, and Indiana. It can be very difficult to avoid successor liability. We're not used to thinking about there being much of such a thing as successor liability in the benefit area in an asset deal, but in the 7th Circuit, you need to be very careful of that. You can avoid having successor liability, but you need to really pay attention to the way those provisions are drafted. So that's multi-employer plans.
Yeah, it sounds a lot like there's a great benefit if people see you early on in the negotiations for the potential acquisition of a company.
Definitely. The sooner the better.
Gotcha. Let's talk about golden parachutes.
Okay. Golden parachutes, payment to execs is contingent on a change in control of the company. There are lots of different designs of parachutes around. I guess I should say that there are silver parachutes and bronze parachutes and tin parachutes, but golden parachutes are usually the ones we pay attention to because the numbers can be very large and the tax implications can be very serious. But with golden parachutes, you could have either single trigger or double trigger. Single trigger, you don't see much anymore. It's just if the business is acquired, the exec in question gets a lot of money. These days, it's much more likely to see double trigger, which is the business has been acquired and the exec is fired or the exec leaves for one of the enumerated good reasons in the contract. Good reasons are what you would expect them to be. the exec is demoted, his salary is reduced, they move the headquarters to null, whatever it is. These get to be expensive. They're expensive anyway because typically, and this goes back to the mid-'80s, there are a lot of them around that are 3 times salary and bonus, and stock rights get vested, and you have a number of people covered that can, by itself, get to be real money. But it gets to be even more expensive from a tax standpoint. I won't go through all the computational issues, but if there is an excess parachute payment, and that by itself is there's a lot of math connected with that. The excess is not deductible by the company, and there's 20% excise tax imposed on the recipient. And there are a lot of golden parachutes around that deal with that problem by limiting the payments to what would not create excess parachute payments. But there are also many around where the exec is given a gross up, so that he's paid enough additional money. And of course, that additional money is subject to income tax and the state and the excise tax, 20% excise tax, to make him whole. So that can end up being a very expensive proposition. There are some planning areas here. If the company to be acquired is private, the shareholders by a supermajority, 75%, can approve parachutes and make them exempt from the rules. Of course, the question I raise is why didn't everybody do that? And the reason that not everybody does that is that the shareholder vote has to be determinative of the exec's ability to get paid. So pretty much what currently has to be done away with, and has to depend when you get something new in return. Also, one of the exceptions to the bad tax effects for parachute payments is for reasonable compensation. And one of the things that's counted for reasonable compensation is payments for a non-compete. And it is sometimes possible to break out a non-compete obligation and have it valued, and so convert a substantial portion of the payment to reasonable compensation and avoid tax implications. In fact, it's not unusual in those circumstances for the exec to be paid even more than he would have been otherwise, but just the company is willing to do that because by avoiding bad tax effects, they net out ahead. So that's true.
Thank you. Thank you, Bill. I've been reading a great deal lately about employee stock ownership plans. Can you talk about that, please?
Sure. If the target company has an employee stock ownership plan, there are a number of things the acquirer needs to pay attention to. Especially if the company is 100% or majority owned. The primary one is that if the company is private, by which I mean doesn't have securities readily tradable on the market, there may be pass-through voting rights to participants. The reason I say there may be is that in the Internal Revenue Code, those pass-through voting rights apply to an enumerated list of transactions. And if the contemplated transaction is not on the list, it doesn't have to be passed through voting. Oddly, there are some things that are treated differently that produce the same result for corporate purposes. A merger would require pass-through voting rights, for example, but for the ESOP to sell all the stock to an acquirer doesn't require the pass-through voting. The other thing that needs to be due diligenced on this is that sometimes plans go way beyond what is legally required in the pass-through voting, and so definitely got to look at the plans language as well. Another important factor is that for ERISA reasons, ESOPs really can't give good indemnification promises like other shareholders if the representations and warranties in the deal aren't true. So that if purchaser is going to have any kind of protection for breaches of reps and warranties, there would probably have to be an escrow or some other kind of holdback, and that will complicate the deal. Another important thing is to manage employee expectations. Employees covered by an ESOP will think the ESOP is pretty much like a checking account. They will think that, after the deal is done, they'll get their money the next day. They certainly won't if there's an escrow. There can already be in place other hurdles like a deferred payment schedule. And so we just need to make sure you do are prepared to do a lot of communication work. I'll just touch very briefly on the fact that compliance issues, you've got to look at whether the plans at the target comply with legal requirements in all respects. But ESOPs in particular, there are some things that are very hard even for private companies to comply with, and so it's something you've got to be very careful to see that they have to stub their toes in ways that could disqualify the plan. Okay, that's ESOPs.
I'd like to talk for a few minutes about, go ahead, Bill, I'm sorry.
No, I was just going to say, David, I know I'd like you to talk about employer-employee issues at this point.
Sure. Bill, I wear two hats. One is the HR and business side, and the other is the employment laws. And one of the concerns that I want to try to head off in this part of the program are hidden costs in any transaction. So one thing that's of great concern is compatibility of the employment policies. Two companies can have very different policies concerning, for instance, vacation, personal time off, and complaint processes. We're going to focus primarily on compensation and benefits. And think of it this way. Not many employees are going to walk into the Chief Financial Officer's office and say, "Hi there, I am so happy that we have merged with X Corp, and in fact, all of us employees are so thrilled by the merger that we want to reduce our compensation and our benefits." We really don't think that's going to happen. So, in fact, many times, for example, with compensation, you're going to have significant disparity in pay for like jobs in like regions across the country. And what's going to happen is, for example, in Chicago, we've got one company paying $35,000 a year for this title, and they acquire a company that's paying $50,000 a year for the same title. The hidden cost is that at some point in time, you're going to have to bridge the gap between the employees in the two companies so that the pay scales are comparable. Similarly, with benefits, you run into problems like, for example, one company matches on retirement, has a different contribution basis for health insurance, gives different terms in terms of number of days off for vacation or for holidays, and what you wind up with is a situation where you're going to have to bring one company to the same level as the second company. And that's going to create headaches and hidden costs. Because, simply put, employees are going to want the better package. Another common occurrence in a merger is that the agreement has ambiguities concerning the expectations for key executives who are going to receive retention packages. And I come across this on a regular basis. In fact, I had one about a month ago where the contract and the lawyers who handled the transaction created about 2 feet of documents, and the documents did not address the expectations for the employees with a retention package, either the employer's expectation for them or their expectation of the employer. And as a result, it was silent. For example, can you change salary? Can you change the job title? Can you change responsibilities? What happens if the employee is not performing? Can you terminate him? Can you terminate him for cause? What jurisdiction would this matter be in, et cetera, et cetera, et cetera? And these are things that need to be addressed head-on to avoid any kind of problems. And the other area of hidden costs would be to know the stats, rules, and regulations governing the jurisdictions where the employer's employees are working. Keep in mind that where the employee works, not necessarily where the employer's office is located, is oftentimes a jurisdiction that governs the employer-employee relationship. And there are different statutes with respect to minimum wage, with respect to overtime, and other potential benefits. And we need to know those jurisdictions. And some cities have extremely liberal policies favoring employees, and it may not be a place that you want to be working. That being said, let's talk about legal compliance and potential audits. Bill, can you talk about tax qualification plans?
Sure. Any 401k plan, pension plan, profit sharing plan, other types of plans has to comply with a host of rules in order to be qualified, and the reason to be qualified is you get a mix of tax benefits that you really can't get other way. Practically always, sponsoring employer will go to the IRS and ask for a determination letter. So the first question for qualified plans is, where are the plans and where are the determination letters? So regardless of whether the determination letter, I need to do a certain amount of due diligence to determine that the plan has been operated in accordance with the law. It's just as opposed to just being drafted in accordance. David, do you want to talk about the rest of the legal compliance matters here?
Sure. On the immigration matter, it's surprising that there are many companies that are more than just mom and pop shops that don't do a proper job with respect to things such as I-9 and record keeping of the immigration forms, making sure that employees are legal and properly permitted to work in the country, whether it's a work visa or what have you. So it really is important to do your due diligence and make sure the files are properly maintained. Employee classification has been a huge concern, and this is both the employee versus independent contractor and exempt versus non-exempt. And what happens sometimes is that an employer selling a company believes that they're in compliance because, for example, they have all the people who are workers who are classified as independent contractors sign in a form that says, I acknowledge and I agree I am an independent contractor. But it doesn't matter what the employee agrees to, and it doesn't matter what the employer thinks is right. Actually, what matters is what the government thinks. And the government is not going to rely on, for example, a contract or a job description. What they're going to do is they're going to see, in fact, what the person has been doing, and then they're going to decide whether this is an employee, whether it's an exempt or a non-exempt employee, based, in fact, on what people are doing. So it's not enough just simply to rely on what you're told. You've got to confirm what people really are doing, or perhaps set up some kind of a reserve in the event that you're concerned about a potential audit or possible litigation. And that also goes to looking at records. For example, how do they maintain their time records? Are they doing the time records properly? For example, does the clock run before they put the uniform on or when they get on the floor? Make sure it's being done properly, and again, kick the tires on it. Ask to see all open investigations, all open litigation cases. Look at the complaints, get an idea of the status of those matters. But also go back in time. Look at recent investigations, recent litigation. A company that has had audits may be more likely to have more audits in the future. A company that has a history of litigation may be telling you that there's another more significant problem, a systemic problem in this company. And that can go to things such as employee engagement, performance, and the likelihood of additional claims brewing. And then look at a history of internal complaints. What complaints have been made to the HR department? How are those complaints being handled? Again, as I said before, if you see a potential problem, address that in your negotiations and in the agreement. Maybe a reserve is put up for litigation cases. Because what happens sometimes when you sell a company, you become judge-proof. And what that means when you buy a company and you're buying a headache, you may not have somebody with a deep pocket available there to help you through the situation. So, Bill, I'd like to talk about the opposite. let's look at this from the perspective of the seller company.
Okay, well, I think you can, it's kind of the reverse of a number of things that we've talked about. David, you mentioned retention agreements for the execs at the target company. If they don't have a retention agreement, they might want to try to get one. Also, the company might want to give them one because you don't want people running for the exits when they know the company's going to be sold. Parachutes, if you don't have a parachute, you might want to try to negotiate one. In terms of more things that are kind of outside the benefit area, but we want to make sure that the company's indemnification obligations and insurance coverage will continue after the deal is done. In terms of reverse due diligence, you'll definitely, if you're planning on hanging around anyway, you're certainly going to want to know what the benefit structure of the acquirer looks like, because that's more likely to be the benefit structure going forward, and find out what kind of shape those plans are in. You have flip side questions as well?
Actually, I think from my side, if people are going to stay, they want to know what kind of arrangements they're going to have. If executives are going to stay, they want to guarantee a contract, a 5-year contract that says, I will be paid this much each year. Maybe it's a 5% increase each year. Maybe it stays flat. They want those assurances. That's one thing I would address, certainly. And you may want to protect certain employees. You may want to say, all right, our employees are being merged in, but there won't be any layoffs for a minimum of 24 months. Things along those lines. What I'd like to do, actually, is, while it's fresh in everyone's mind, is create a checklist. So we can take the checklist on the points we talked about today and then add whatever you think is pertinent in your business situation. And the first thing was the defined benefit pension plan, the retiree medical that we talked about, multi-employer pension plans, the golden parachute, employer stock ownership plans, the employer-employee issues, the compliance and audit, and the flip sides. Now, Bill, are you available if people have questions about things that may be coming up in the future?
I most certainly am available, and I would welcome calls and emails. And I thank everyone for joining us this afternoon.
Yeah, thank you very much.
Thank you, David and Bill. That was really informative. And thank you to everyone for attending the webinar. A recording will be available on the Wagner Law Group website shortly, as well as the PowerPoint slides. We had a number of questions, and we don't have time to answer them now, but either David or Bill will be in touch with you with the answers. And if you didn't write your questions in the chat box, please feel free to contact either David or Bill if you do have questions. Thank you very much.